The Chair of the Alliance for Finance. Thank you all for attending, and thank you to our good friend David Sorensen from Morrish Solicitors for providing the first update of the year for the Alliance for Finance and its affiliates. Today, David will be covering the Employment Rights Act 2025 and the effect on trade union rights of access, government responses and draft code of practice. There'll be time for any questions at the end of the presentation, so please add your questions to the chat facility as we go along. David, I'm sure this is going to be an interesting update, and I'll hand over to you so that you can get started with your presentation. Thank you.
Thanks, Anya, and thanks everybody for joining, and thanks for letting me be part of the update. I'm going to be talking today about the Employment Rights Act again. But the actual subject we're going to look at is the trade union right of access, and this is the right to roam, as the Daily Mail has called it, in terms of the what they have termed Angela Rayner's workers' rights revolution. So we'll be looking at that and looking at that in detail. I'm just looking on the slides. Do we just need to move ahead there, Anya? Oh, thank you very much. That's wonderful. So if we can just move forward a little bit, there's a little bit of spiel about us, which I think you know all about. You've probably seen that many times before, so we can move on quickly. And then look, if we move forward to the next slide, we can just look forward to what we're going to be covering today. So this is part of the big piece of the Employment Rights Act, which is easily the biggest single not just an upgrade, but a large, massive injection of employment law protections. And particularly the aspect we're looking at forms part of the trade union kind of turbocharge of trade union rights in the workplace. And so it forms part of that framework. And just to go back a little bit, because I think it's worth reminding yourselves, obviously the government are a little bit busy at the moment, and Mr. Starmer's got a bit on his hands today, but it's worth looking back to the kind of principles behind the Employment Rights Act. And principally here, it's not only strengthening individual rights and workplace rights, but it's all about the communication is about improving union involvement in the workplace and union rights. And it's worth remembering that this isn't just, this is part of the growth strategy the government adopted as well. So it's seen that union access to the workplace is a fundamentally important right. And so what we're looking at here is that very same thing, the right of access to the workplace. And the actual guidance identifies that the UK's employment laws, I'll just quote directly, products of the 20th century that have not kept pace with how businesses now employ people, nor how people experience work. So trade unions have no general statutory right to access workplaces, leaving engagement dependent on voluntary arrangements that vary significantly between sectors and employers. So this is designed to bring in the statutory right that would apply across all workplaces. So let's look a little bit at the history. The government responded to the consultation quite recently, back in April, and issued a draft code of practice for consultation. That's currently underway, and the consultation closes in about 8 days. And then the intention is the right of access will take effect from October 2026. So we haven't got all the detail as yet because the consultation is still underway, but it is anticipated that the consultation will be responded to quite quickly, and then there will be secondary legislation setting out more detail of how it will work. Obviously, the consultation may mean that the current code we have, the draft code, changes. So these slides are based on the current proposals. So as always, with forthcoming law, expect change possibly, but it gives us a good sort of look at what may well come in, if it does indeed come in October, which is when it's expected. So let's look at it. The objective really is to make union access to a workplace the default. So rather than exceptional, it's the default position. and also to help the access within non-traditional workplaces, so fragmented, hybrid, remote workplaces. And also, regardless of whether the union that's applying is recognised and regardless of whether it has members in the workplace. So that's quite interesting and quite a change. And this is identified to simplify, sit alongside what is going to be a more simplified, it is expected, statutory recognition regime. And also recall the worker right to join a union written statement. So this is part of a kind of series of pro-union, union-friendly changes. So sitting alongside a more simplified recognition regime and also the right to join a union. So this is part of the trajectory. So if we just move forward a little bit in the slides, we can then see that what it is doing is creating a statutory right for independent trade unions to access the workplace. And that is going to be in a certain way so that there is, like I say, a draft code of practice, which also has draft letters and sort of application and access documentation, which are quite straightforward and they look quite good. Hopefully they will come in. And it doesn't just involve physical access, but also digital and remote access. So we're waiting for more to come through, like I say, and we will know more in due course because certain bits of legislation have got to come in to set the process to approve the code of practice or amend it and approve it, and then also establish the powers of enforcement, which we'll come to in a minute. So again, if we can just move forward a slide. I'm going to break it down to what it involves. And again, this may be subject to a bit of change, but this looks fairly solid and won't change in that there has to be an access purpose. So the union that applies for access can only apply for certain reasons, but they're wide. So it's to meet, support, represent, recruit and organise workers, or to facilitate and assist collective bargaining. The workers to be accessed, as it were, don't have to be members of a trade union. They don't have to be members of the trade union applying and the way it's currently drafted. But the one thing that would not be covered for an access purpose is organising industrial action. So that's excluded from the right of access in this framework of legislation. So the expectation is that it's going to be negotiation, really. So apply firstly for voluntary access and discuss it, negotiate it. The agreement about access has to reflect the nature of the workplace, the worker demographics and operational safety and legal reasons, which are considerations that we'll look at. And then where the agreement fails, so the agreement isn't working or there can't be an agreement reached in the first place, the CAC, so the Central Arbitration Committee, are involved. And they can then decide and determine whether access occurs and on what terms it is. So the employer's consent or agreement is no longer decisive. So that that's a fundamental part of this. Like I say, voluntary access is encouraged before a formal request is made. So that's the expectation. And there is also a proposed model access agreement. And if the union requesting asks simply for the model access, then that's a more streamlined process as well. The process, like I say, has to be in writing ultimately, emails preferred, and involves contact backwards and forwards between the independent trade union and the employer. And it has to specify a number of things. Now, we'll see whether the forms that are proposed as part of the consultation come in, but it's like a sort of completing a kind of passport application form in many ways. You kind of ask, specifying in tick boxes and so on. So what are you seeking? Is it physical, in person? Is it digital access? Is it both? What's the nature of the engagement there? What's the rationale behind it? What do you need the employer to do to facilitate? And as identified there are some standard templates. And the intention is to be transparent and as consistent as possible as part of this process. If we move to the next slide, that then just shows that the timeline process that's identified. It was originally much tighter and actually quite unrealistic. So it's better to give it a little bit longer, in my view, just to make it practically worthwhile and just flow better. But the response times are still quite relatively tight. So the employer has 15 working days to respond. There's then a 25 working day negotiation period, and then a referral deadline of 55 working days to the CAC. And the parties can agree extensions. And it's anticipated that once the CAC is notified, a caseworker is assigned, and the communications, any agreements go backwards, go to the CAC. If there's going to be employer delay tactics, there are escalation routes to take, but the employer ultimately has to come back and say, do they agree in full or in part, do they reject it? So ultimately, all agreements are going to be with the CAC, even those that are just voluntarily negotiated. So the CAC is going to be closely involved, because the CAC is ultimately the enforcement authority, not an employment tribunal, not another route, but the CAC. And the CAC will decide whether access should be granted and the terms of access where the parties disagree. So, as I said before, if the model agreement is anticipated, if the model agreement is used, then that process will be fast-tracked, because that will then allow only one member of the CAC panel to have to hear any applications in the fast-tracked model kind of process. With the others that fall outside the fast-track model process, it's going to be a panel of 3, it's expected, who would hear that. So really, the model terms are the streamlined route through to get access. So what do they include? Well, we're talking about access, and of course, it's not just walking in the door, it's also digital access, it's remote access. But of course, in terms of the visit, in terms of the meeting, there has to be 5 days working notice for the first one, and then at least 2 working days notice for subsequent visits. And the expectation is there will be weekly access. So that's the default position. And each access agreement is expected to have a 2-year expiry date. So it's anticipated none will last for longer than 2 years, which seems quite tight to be, quite surprisingly tight, but that's the sort of expected life expectancy of each agreement. But like I say, following the model terms will allow a speedier process. It's going to be down to the CAC resources ultimately, because they could be pretty busy on this. So we'll see. So the question really is, that sounds great, and it does. I mean, it really is a kind of a turbocharge to existing access arrangements, because we've got to remember that this is, I should have made clear at the start, this is a specific access arrangement under the new provisions of the Employment Rights Act. But many of you, I'm sure, will appreciate that there are some access rights for statutory recognition processes. So I think you've got to, for the purposes of this presentation, I'm just dealing with this standalone right. But of course, there are some wider changes to statutory recognition, and there's an access process currently that's also likely to be changed probably in October or possibly into next year. So that these are complementary but separate in that way. But focusing on this standalone right, there are rights for the employer to say no, but they are relatively limited. So for now, if the employer has less than 21 workers, it can refuse, but that's going to change in time, it's expected, so that employers with different sites or with associated companies can be combined. But for now, that's the expectation. There's going to be a small business kind of exception for less than 21 workers. Obviously, if there is a right to refuse if the request is going much beyond the model agreement, so that could be rejected, say, if the CAC finds that's not appropriate. But then there's a few other exceptions. So national security or crime prevention, it's going to be fairly rare, but there may be some national security sites where it will not be allowed, say MOD or some kind of quasi-military sites, things like that, Secret Service and what have you. So those exceptions. Crime prevention, again, I think that's going to be relatively limited. We need a bit more detail on how that will operate. But understandably, there may be some exceptions to access. But the reality is, we'd hope that there can be negotiated outcome to that. It could be that those individual, the workers, could have access arranged off-site, and the employer, again, under the current drafting, would have to give reasonable access and reasonable support to that. So a hotel down the road, for instance, may be possible. So there are alternatives, but these are kind of going to be unusual cases. It gets interesting where there's already existing recognition and, of course, competing access requests. And that's really where the code of practice is going to be quite interesting as to how that evolves when we get the responses later this year and into the summer. Because if there's already a recognised independent trade union in place, access can be refused and not allowed. Where there's an existing statutory recognition process going underway, again, that can be refused. And also where there's multiple access requests. So if the workplace is so popular, you get multiple unions wanting to access it, there's going to be a facility there to say, hang on, whoa, we'll only deal with 1 or 2 or 3. So it's going to be quite interesting in terms of competition, I suppose, as to how that will work. So we need to keep an eye on that as well. And then ultimately, there's another exception, I think, for health and safety. So if it's a workplace that's particular where there's a health and safety reason why access cannot be provided. Again, I think that's going to be rare, but there could be certain scenarios where it's a very physically risky workplace, say, and access isn't realistic. But there'll no doubt be other ways of, again, like I say, accommodating that. And it could be instead, for example, don't need a hotel down the road, but you have online access to the workers and you meet with them virtually anyway. So there's ways and means of getting around it. So if we look at then what the access involves, it's active interaction, it seems. So physical or live kind of virtual access, and access that takes into account different working patterns. So there's an element of reasonableness to be followed, so that access isn't just necessarily strictly during typical working hours or Monday to Friday, although it is I should say the legislation is factored around working days, but where there are unusual shift patterns, for example, then that can be adapted. So it is going to be flexible in terms of the CAC. So I think when employers and unions are negotiating, it's worth taking those things into account in advance. The employer has to take reasonable steps to facilitate it. So we get into, there will be some employers that want to try and game it, to try and avoid it. So we're looking at potential preventative measures being built into the code, and there are some already. But there are limits on what an employer will be expected to do. So, for example, no significant requirement to build a meeting room or significant new IT investment if digital access is limited. But again, practically speaking, most workers will have some form of digital access or their own device in most situations and be able to at least be involved digitally. So, and digitally is obviously particularly important for those who are like hybrid and remote workers, again, coming to those to get around those kind of health and safety issues and things like that. And the expectation is the employer will allow access via the employer's digital platforms. So virtual Q&As, webinars, and the like. We'll come on to some issues in a bit, because obviously there's GDPR and data issues, which we'll touch on. But the other point here to expand on this is the access can be direct digital access, union contacts the workers themselves, or indirect, which might be the safer way in terms of GDPR, for instance, where the employer arranges or allows indirect digital access. So there's an intermediary, or the employer is an intermediary. But obviously there's also privacy issues, because built into this process is a right of privacy by the workers and by the union. So it's going to be, again, that's going to evolve really into how that will practically work. Because of course, direct access, this legislation can't override the GDPR, and so hinges on worker consent, which workers may provide to an employer. They may give direct consent, which might be adequate, but they might not. And they may be reluctant to give that to the employer. They might give it direct to the union and so on. So there's sort of ways and means of working through that. And in terms of what physical access means, well, it's what you'd expect. On-site meetings, existing facilities, the normal canteens and break rooms. And for instance, it says where the employer has a typical meeting room where they meet their own employees, the expectation would be that the union gets access to the same meeting room. So that's, again, kind of interesting how that will work. And so you can see it gives quite a significant level of access here. This isn't what I would see as a paper right. But of course, one limitation may be how much funding and kind of support the CAC have to process these, because there could be very many. And then, of course, ultimately, it has to have some teeth. And I know you probably heard me go on time and again about how many statutory bodies don't have real teeth. Well, actually, this appears to. Again, we haven't got the final, all the final details yet, because elements are under consultation, as I've said, with the Code of Practice. But the penalties here are £75,000 for the first breach, up to £150,000 for the second, and then repeat breach is £500,000. Now that's a repeat breach, could arguably another breach, another breach, another breach, and so on. And £500,000 for each breach is significant. So sadly, that's payable to the CAC and goes into the government pot, or the government debt, I guess, and not payable to the union itself. It's one of those. So it doesn't benefit the union in terms of the time and effort spent into it, but it will go into the government. And obviously, it will depend on how many fines are issued. We can be probably a bit sceptical, because often the actual data shows that very few are. But again, it's quite a significant threat. And I know from looking at sort of the employer commentaries and employer lawyer commentaries, the £500,000 fine seems quite scary to them. So that will hopefully be a motivating factor and be preventative medicine. Hopefully that will mean they'll take these seriously, which they appear to be doing. So what else can the CAC do? Well, they can vary the access agreement, and they can order remedial action. They can order the employer to take steps, union to take steps, and they can publicly name and shame. And then, while this isn't yet brought into place, it's expected that any appeals about the CAC will go to the Employment Appeal Tribunal in London and Edinburgh, so that those would be covered. Now, the reality is there, I'm afraid, like with every element of the Employment Tribunal, sorry, I'm Mr. Doom and Gloom again, there are significant delays getting to the Employment Appeal Tribunal, particularly in London, so that could hold things back. So what we could have is a practice where the CAC actually deal with things quickly, but then it goes into an appeal process, which could take a year or two or three to go through. But let's not be too negative, because hopefully most employers won't want to get into a legal battle over this. They'll want to try and resolve it on the ground, as it were, because that's how it's designed to be. So areas of difficulty, well, personal data, giving access, of course. The GDPR protections are very strong, and of course employers, unions, individuals are wary about inadvertently breaching personal data protections. So it's managing that process carefully. It can be done, it just takes care, of course, and also having suitable digital structures to allow it to happen. And I think there'll be more guidance issued on that to ensure that the digital structures are strong enough and suitable for this process of access. Protections for unions and officials. Really, there are changes to protection rights and facility time rights and so on that are linked to this. But again, it's a question really in terms of, should a union official behave inappropriately or be accused of harassment in some kind of context like this? It's not clear how that will be dealt with under these provisions. So I think unions and their representatives getting involved in accessing workplaces they're not familiar with, or they've just got to be a bit careful there and prudent in terms of that process. I'm not trying to flag up anything particularly scary, but it's just, see, there's got to be awareness there. Obviously, that then plays into visiting certain workplaces where DBS checks, safeguarding checks are required. That's built into the code as well. So it's obviously sensible that schools, hospitals, other places have to have certain requirements, which is totally understandable. And then coming back to digital safety, where CCTV and so on, there's quite a bit in the code, and we hope it makes it through in terms of rights to privacy, because one could see CCTV cameras in meeting rooms recording meetings, which of course will be inappropriate, and the code makes that clear. So we've just got to be careful about that. There's always a fear about union reps being blacklisted or identified, and of course walking through corridors with CCTV cameras and so on. There's got to be a balance there, but the intention is, again, that the union is protected, the reps are protected, the workers are protected for privacy. So those meetings shouldn't be recorded in any way. Records shouldn't be kept of who's in the meeting and things like that. So there's going to be a bit of a tension there, but that's sort of one area to focus on. So I've kind of roared through it because I should say, actually, I sort of came into this thinking this was a lot more complicated than it is, because, of course, in terms of a lot of the ERA changes, a lot of them particularly linked to guaranteed hours and 0 hours contracts. The machinery of processing those types of issues is very complicated, very paper heavy. This is less so, which is quite refreshing. There's going to be arguments about it, of course, but actually it becomes a little bit more of a straightforward process, it seems to me, subject, of course, to the secondary legislation and the code of practice coming in as they have been, they're expected to be, because there could, of course, be changes. There could be additions. There could be, during the consultation process, changes made to make it maybe less sort of union friendly, as it were, but we'll see. But if it comes in as anticipated, it certainly will open up access to more workplaces, and particularly those in non-union or traditionally non-unionized sectors. It brings in as well a kind of momentum to that, but also a process. So weekly visits, two working days notice of a meeting and the like. So it brings in a kind of planning process that can be anticipated. It also complements the changes for potential changes coming through for recognition and other trade union changes as well, and will, of course, strengthen and enhance, clearly, obviously, union involvement in the workplace, which will be extremely helpful to everybody concerned on the call, of course, and generally better for society as a whole, to allow more union access in terms of equality, rights, pay, and terms and conditions, and so on. So there's a bit more to see, but that's really it in a nutshell. I think, like I say, the consultation closes in about 8 days' time. We then hopefully will have the secondary legislation, just checking through my notes, and then have the revised code of practice. And at the same time, there should be more information coming through on the other government changes, some of which have closed on consultation. We're awaiting more detail so that it comes through. But it seems to me that this overall is a very union and worker friendly element of the, well, all of it's obviously worker friendly in terms of the Employment Rights Act. There's arguments that some of it didn't go far enough, but clearly it's all moving in the right direction. And this certainly is expanding union access in the workplace, particularly those where they're not traditionally unionized. So it will increase that. I think any other points? Sorry, I was going to just checking through. No, I think I've covered it in a nutshell. And of course, with the news, what this might be, is this going to be Mr. Starmer's swan song, or will he be continuing? But I won't get into the weeds of that one. But let's hope that any changes to Prime Minister don't change the overall direction of travel.
That's great, David. Thank you for that. Lots for us to digest and think about there. Has anybody raised any questions, Fiona?
No, not that I can see, Anya.
No.
I've got one for you, David, though. Are you anticipating like any sort of strategies by employers to try and get around parts of this? For example, introducing specific contractual clauses to individuals or anything like that?
Yeah, I think it's going to be quite difficult in a way, because it's quite, I dare say it, it's relatively straightforward. So I think we'll have to wait and see, because I think the access that any kind of tricks played by the employer are going to be more kind of tactical on the ground to make life more difficult in a day-to-day level. I think it's going to be hard to try and change terms and conditions to to prevent this, really. I suppose the one element of it is that we're very reliant on the CAC, because any access agreements are, even if they're built into recognition agreements or collective agreements, procedural agreements, and so on, also it identifies they're unlikely to be legally binding. So that means that it is unlikely, that the current position is, for a union to be able to take legal action against the employer, and also possibly the workers. So now, of course, there may be other action to be taken, industrial action and so on, but it just means that the actual remedy is with the CAC. So that's one area where it's very reliant on the CAC taking action, and also reliant on the CAC issuing penalties, because ultimately, if the penalties are teeny, then it could well be that employers stop worrying so much about it, like sadly they have in other situations, like health and safety to an extent. Health and safety executive 20 years ago had a lot more funding, a lot more power. It still has powers, but the visits to the workplace are so rare that the wrong kind of employer is less concerned about it. They'll put it down as a commercial risk, really. There may be a visit one day, but it's so rare. So we don't want it falling into that category. But in terms of avoidance, the biggest avoidance they're trying to do at the moment is it's the kind of right-wing media, really, portraying this as some scandalous workers' revolution. And I think the Daily Mail's called it the right to roam. I've heard worse phrases, really, that sort of giving union power and suggesting it will be out of control and things like that. So there's definitely a sort of backlash from certain businesses against it. And that's why I think it's key, like any part of the employment rights sector, to keep a really close eye on what develops over the coming months. But if it comes in October, it's not far away. So it's coming around fast, and let's hope it keeps up momentum.
Great, thank you. Oh, there's one come in from Ricky Markham. Is there more detail on the right of access and protections for unions who already have a recognition agreement within the workplace?
That's part of what we're waiting more for from the government in terms of the secondary legislation. So we will know more over the next month or two, really, to fine tune that detail.
Okay, thank you. Does anyone else have any questions or comments?
No. Okay. Well, thank you very much for that update, David.
My pleasure.
Obviously, we can share the slides after, if Fiona wants to share them with everybody that's attended today, or if people want to put requests in for them. But again, thank you ever so much for, sparing your time and coming along to give us that update, because it's really interesting stuff. And as you've said, October's not really that long away. So yeah, it'll be interesting to see all the other updates that come through. Fiona, has something else come into the chat? So look.
Not that I can see.
No, so there's no more questions, David, but as I say, thank you ever so much for that, and thank you to everybody that's joined the seminar this morning. Much appreciated, and we'll be in touch with some further seminar information for later on this year. Thanks,
thank
David.
you very much. I just want to quickly say just one thing. We are doing on our newsletter, we are going to do regular updates. So I think this is going to be a feature soon as well. So feel free to sign up to those. Also, the recognition changes that are coming, they're very much linked to this. So I think the answer to Ricky's question will be not just about the independent unions and recognition in this context alone, but also in terms of the changes coming through. And also there are legislative changes to prevent inappropriate practices in recognition as well. So there's quite a big piece coming down the line there. So more detail on that soon. And I'll happily, if you'll have me, come back and tell you more about that in the autumn.
Yeah, we'd love that, David. So thank you very much for that.
All right, thank you.
We'll send a note around. We'll send a note around if you've got a link to give us that we can share for delegates to request your newsletter and things like that. So if you want to send us that through, we can send that through on a future newsletter. So that'd be good if people got registered for those updates, because they're coming thick and fast, aren't they?
Oh, yes.
Thank you ever so much, David, and thank you to everybody that's joined today. We'll see you soon.
Thanks very much.
Bye.
Take care.
Bye-bye.
Bye.
Bye-bye.
Bye.